so much, Phil. I appreciate it. Appreciate your generous introduction. And we at Pioneer are really grateful to you and President Fahey and Thomas More College for co-sponsoring this excellent and timely event. It's an honor to be with you this afternoon, especially with such a distinguished lineup of folks and panelists whom I admire so much. I also want to give a special thanks to Mike Gillerin, who has done so much important work for us at Pioneer in our efforts to support Espinoza v. Montana Department of Revenue. We're so grateful to Mike and Dwight Duncan, who authored two excellent legal briefs for us on what we think is a potentially landmark case against bigoted legal barriers to school choice. But before I talk more about Espinoza and Blaine amendments, I'd like to say just a couple words about this law professor's, frankly, bizarre but not unsurprising comments about homeschooling. As I'll discuss, narrow-minded opposition to school choice sadly has deep bigoted roots in the 19th century and across American history. This professor, to my mind, has simply said and given more modern voice to what I think a lot of people who have observed K-12 education for decades have also observed, which is unmistakably many across the K-12 education system believe that they know better than the parents themselves, what's best for their children. The reality is too many in public education oppose or have outright hostility to almost all forms of school choice, including private and religious schools, charter schools, vocational technical schools, and many even oppose a key educational option for the moment, online or digital learning. But homeschooling, as Pioneer's 2017 white paper by Bill Hewer says, is the ultimate choice. This should be, and it is right that it should be that way, because the fundamental duty of parents to order and direct the formative education of their children is in fact sacred. As an aside, I thought it was a little bit unusual that there would be such a strident criticism of homeschooling when in fact over the last several months we've gotten new data from NAEP, the Nation's Report Card. It's administered every couple of years. It's a sample test, goes back 35 or 40 years. And the data was really pretty disturbing. The reality of it is we live in a country where 2/3 of the students are not reading at grade level. And just a couple of weeks ago, there was additional NAEP data that revealed that only 1/4 of the students in this country are proficient in civics. So in the key areas of both literacy and civic knowledge, I think many people believe that the K-12 public system has a great deal to answer for. But at Pioneer Institute, where I work, it's a small think tank in Boston, and going back 30 years, we've done lots of work on school choice and all kinds of papers and events on academic qualities. I've always been particularly grateful for the work that the people in the homeschooling community have done, as well as people in the religious schooling community as well. We fought the Common Core standards that have been implemented over the last 10 years, and we went to approximately 20 states when we did that. And I got to tell you, when we were in with those audiences, I'd say a full third of those parents who are deeply engaged, knowledgeable, in some instances more knowledgeable than policymakers, were the backbone of that opposition. And we now know from NAEP data that in fact, the Common Core has done some pretty significant damage, not only nationally, but in high-performing states like Massachusetts. Now, Massachusetts, my home state, has a great deal to be proud of. Its public system has engaged in pretty dramatic and I think historic reforms over the last 25 years or so. We had remarkable success on the NAEP, been the #1 state on NAEP going back to 2005. We're the only state that's internationally competitive. We have great charter schools. We have great voc tech schools that are both national models, as well as Metco and a growing number of homeschooling students. And we're really proud of those accomplishments. But I want to highlight just one school choice option that is germane to the conversation we're having about Espinoza and to Blaine amendments and the various barriers to private and parochial school choice, and as well as homeschooling. Massachusetts is home to the best Catholic schools in the United States. The couple of measures that we have in common demonstrate that the Catholic schools, which if aggregated would actually be the largest school district in Massachusetts, on the measures we have in common, significantly outperform the Commonwealth. And that's saying a great deal because, again, Massachusetts has done historically well in terms of its academic achievement over the last 25 years. But the Catholic schools are really struggling and with their enrollment, and they're struggling not as much out of their own fault as it is something that Massachusetts should not be very proud of, which are Blaine amendments. These are bigoted 19th century anti-Catholic legal barriers to private and parochial school choice. And in fact, Massachusetts has among the worst and among the oldest in the country, and they're so bad and early that they were established before the Civil War by the violently anti-Catholic Know Nothing Party. At this point, there are 38 states that have these Blaine amendments, including Montana, the home of Kendra Espinoza, a single mom, 2 daughters, Naomi and Sarah. She's the lead plaintiff in Espinoza v. Montana Department of Revenue, which was heard before the U.S. Supreme Court in January, and we should be hearing their final decision anytime soon, this spring. I always say to people internally at Pioneer that this topic of school choice and Blaine amendments really is the most interesting topic we work on. We do a lot of great work around academic standards and teaching history and civics and science, but it really is the most interesting. And the reason why is that it has this unique combination of education and law and religion and politics and history. And so in order to kind of familiarize people with the vocabulary and some of the historical touchstones around this case, and to kind of help put in context, from my point of view, the comments from this law professor, I want to just give you some of these touchstones. So it's been mentioned sort of variously throughout this seminar that a lot of our original ideas about education go back to the founders. And folks like John Adams and George Mason and Thomas Jefferson and Alexander Hamilton were men of the Enlightenment. They built our laws upon the natural law and reason and science, and not just respect for religious tolerance, but religious liberty, full-throated religious liberty. In many ways, they were much more open-minded than our society is today about issues of church of state. And the reality of it is that early state constitutions, like the Massachusetts Constitution and the New Hampshire Constitution, they predate the federal Constitution, which is virtually silent on K-12 education reform. But these state constitutions were quite specific. And simply put, it was the intent of early America to keep education as close to parents and local communities as possible. And in fact, in many instances, legally sanctioning public support for religious instruction by parents. I think they saw it as a kind of free market of educational options. George Washington, in his 1796 farewell address, made clear the connection between self-government and religion. And he described our constitutions as designed to perpetuate what he described as the sacred fire of liberty. Again, there probably isn't anything that's more sacred to parents than the education of their children. But this kind of more tolerant view of civil society really began to give way in the 1830s, 1840s, and 1850s to religious intolerance, primarily as Irish immigrants fled the potato famine and arrived into Northeast cities, including Boston, New York, and Philadelphia. And with them became this nativist impulse to begin to wall off the educational options and freedom from parents and local religious folks. And in 1854, and I'll just speak to my state here, Massachusetts, Again, the violently anti-Catholic Know Nothing Party won the biggest landslide in state electoral history. They were led by their governor, Henry Gardner, who incidentally, his portrait is right next to the main entrance of the House of Representatives in Massachusetts still today. But he and his party passed a wide swath of appallingly anti-Catholic, bigoted amendments. In fact, their proto-Blaine Amendment really set out to undo what it was that the founders intended, which was having the money flow more freely back and forth between the public and parents and religious instruction. And then a second Blaine Amendment was passed in 1917, which prevents that first anti-aid amendment, or the Know Nothing Amendment, from being repealed via the ballot box. It's a kind of legal protective coating around it. Well, if you fast forward about 30 years to the 1880s, James G. Blaine of Maine, he was a prominent Republican politician of the late 19th century. He and President Ulysses S. Grant stoked anti-Catholic sentiments and pressed for a national Blaine Amendment, which would again wall off parents from public dollars, particularly Catholic school parents, from religious dollars. Now that narrowly was defeated in the US Senate, but where Blaine failed, the states began to pick up this torch of and gradually throughout the late 19th and early 20th century, we arrived where we are now, which is, 38 states have these Blaine amendments. And that brings us to Kendra Espinoza. So Kendra, as I mentioned, is a single mom from Montana, and her state has a Blaine amendment. She and her daughters, in conjunction with the Institute for Justice, have brought their case in Montana to first their state Supreme Court, but they've taken it all the way to the US Supreme Court. So Kendra suddenly became a single mother, and she sought better educational options for her daughters out, because the reality of it is that they were being both bullied and they were struggling academically in the public school system. They through an educational tax credit program that was passed by the state legislature and signed into law by their governor, their children were able to thrive going to a parochial school. But then the Department of Revenue challenged the existence of this program, this education tax credit program. And just sort of simply what an education tax credit program is that it allows individuals and corporations to make a contribution to a third party entity. They get a tax credit for that. Then the third party entity disperses that money to parents who are able to use those resources for the educational option of their choosing. And about 250,000 students or more benefit from these kinds of programs across the country. But the Montana Supreme Court struck down the Montana education tax credit program that Kendra and other parents in Montana needed very badly. And now this question is in front of the Supreme Court. And so the central question here is at stake is, whether states will continue to be allowed to use bigoted 19th century Blaine amendments to discriminate against religious families and deny them a state service or benefit, in this instance, education. Now, I will say that determining what it is that the Supreme Court is going to do or how they're going to rule is a bit like analyzing Mona Lisa's smile. But the lawyers at the Institute for Justice and Kendra, I think, are cautiously optimistic that they're going to prevail. And this would be very much a landmark decision if they rule the way we hope they will. That is to say, it will rip holes in these state of Blaine amendments that will make it possible not only for education tax credits, but then it really opens up a wider state of play for the political process and to play itself out. And this is where it's really so important and vital, the work that you folks are doing, because these kinds of openings, these legal openings, will then make it possible for greater access, if state legislators avail themselves to it, education savings accounts and other tax credit programs and support of private and religious school parents through a variety of other different choice mechanisms. And this is vitally important because, as we've just learned with this article from this law professor, there is bias and bigotry, whether it is 19th century style bias and bigotry that you find through Blaine Amendments, or bias and bigotry that you find through intemperate remarks from well-placed law professors. And our hope, obviously, is that with the success of the hopeful success of the Supreme Court, that parents will be allowed to explore even greater opportunities to educate their children according to what Thomas Jefferson called the dictates of their conscience. So I can't tell you how grateful I am to Thomas More for all of your excellent work on this topic. I'm very grateful for all the work that the homeschooling community has done around the support and advocacy of their own schools, but also for their work that they've done supporting the academic improvement of the public schools and other school choice mechanisms by giving us such a good example of the work that they do. Thanks.
Thank you very much, Jamie. I'm currently unable to see the screen. I've done something with my computer, but thank you. I'd just like to make a reflection, and I'm grateful for one point that you made, that the founders and the original crafters of educational policy, particularly in Massachusetts, did so with a firm understanding that they were working to empower parents, to give parents more resources with which to fulfill their responsibility. Now, if we are successful, if Kendra is successful, Kendra Espinoza is successful, then parents will have more resources, should have more resources in the form of state support in various ways. But I think it's also worth reflecting on the fact that if the Supreme Court essentially gives the green light to strike down these Blaine amendments, we also will have erased something that defaced the original intent of the founders, so that philosophically we would be back to the original educational goal, which is to empower parents. Am I overstating the case?
No, I think that's exactly right. Again, in so many regards, I think the founders got a lot of these state, local, federal arrangements right. And, I think what we've seen over the last 25 or 30 years at least has been a dramatic shift, not only away from state and local authority, but towards federal authority. Yes. And, I think that there has been, a lot of concern, and a lot of people have voiced strong opposition to that. But even given the opinions of the people that are proponents of that, the proof of the pudding is in the eating, and the NAEP scores, the nation's report card, the measure of academic performance has really been either flatlined or declining for decades. This huge movement towards the federal role, or even a more consolidated state role, it hasn't yielded any results. And I think that again, the onus is really on these proponents to explain why we keep spending hundreds of billions of dollars at the federal level, and in some instances, tens of billions of dollars at the state level, when in fact we're just migrating the authority further and further away from the family and the parents, the ones that are most intimately connected with the lives and concerns and intellectual well-being of their kids. And the founders, I think, were very wise about these things. They did not, the state constitutions are clear about it. The federal constitution is silent on it. And even at this late date, the federal government contributes about 10% of the funding of K-12 education, which is really a very modest amount. And in most states, or in many states, it's still largely locally funded. So I think that the founders got it right. And I think that, hopefully with this decision, we can begin to right the ship in terms of getting the the authority back into the hands of the people that are most intimately connected with their school children.
And the best guess for when the decision will come out is in June?
May or June, yeah. So, I
So-
mean, again, but it could be any day. I mean, we have pretty close contact with the Institute for Justice, who incidentally have done tremendous work on this topic, and both they and Kendra had been remarkably courageous, and she is really a terrific woman. We had her at a couple events this past fall. She's really a terrific person to interact with. She brought her children here, and so I think everyone is waiting with fingers crossed.
Thank you, Jamie Gass, for giving us some good news to close with. I'd like to express my appreciation to all the panelists. Thank you to Amy Fahey for having the idea for this conference, to Mike Gillerin for helping to make it happen in many ways, to William Fahey for agreeing to host, and of course, to all the people who are out there watching this and making it happen, and all who will be watching it later on YouTube. It will remain on YouTube, so pass the word to your friends and neighbors. If this is your first acquaintance with Thomas More College, I strongly recommend that you learn more, particularly if you're a homeschooler, because I think you might find that we're an institution with the same blood type. If this is your first acquaintance with our Center for the Restoration of Christian Culture, please get on our mailing list and learn more about events like this. It's unusual for us to be doing it on the internet. Usually we do it in a more intimate setting, but if this is as successful as I think it may be, we'll probably be doing more.